So this is the governmental interest test. I call this the potential third branch of Eaton Way, because you could branch into the first restatement, the second, or the third analysis, which is going to be governmental interest. So I actually like this one the best because I think it's the simplest, because there's the least amount of steps, I feel like, and the least amount of nuance. But I could be misunderstanding it. In that case, you don't have to watch this. You know, I'm not a teacher of any kind, and there is absolutely no guarantee associated with this video. I'm not hired to work with any university or bar prep at all. So, you know, watch at your own risk. But I broke it down to 3 steps to try to make it very simple. So governmental interest in its most basic form is really just think of like a distilled version of the second restatement regarding the specific portion about who has a greater interest. And I would say it's more so that last exception that was mentioned regarding who had a more material interest and whose law should apply just out of fairness. And that's kind of how I think that this kind of came about, but it also came about because of a professor and from academia actually that established it. I believe his name was Curry, and it was mostly based off of what he wrote. It was one of those rare articles that actually went, I don't want to finish that sentence, I don't want to hurt any law review people. Okay, so first question to ask is the interest of the actual states. So this is actually very similar to the first question in the second restatement. You're literally going to look at the interests of both states and say, okay, what was the reason that they created this law in the first place? What's the underlying policy? What were they trying to do? Were they trying to protect somebody? If so, were they trying to protect their citizens? Are they trying to protect the environment? What were they trying to accomplish by adding this law or further distilling this law? What was their, overall desire and outcome that they wanted to get by making this law? What did they think would come from this law? So their overall interest. As I've taken a step further, and you have to decide whether the purpose behind the law is a loss-shifting law or a conduct-regulating law. Now, loss-shifting laws can be like a guest statute, or it can relate to a pro-plaintiff recovery type of situation. It's more about protecting the individual. So if you have any type of law that specifically really, when you look at it objectively, this is about protection, and you have to ask yourself, okay, what are they trying to protect? If they were trying to protect somebody that got hurt, and they want to make sure that person can be made full, you really cannot fix somebody that's gotten injured, really, and their body's never going to be the same, but can we give them what they're owed and due based on this injury? Or if the whole point of that law is to try to protect that person that was wronged, it's probably a loss-shifting statute, because we're trying to potentially shift the loss to the person that we believe should be punished. But now, loss-shifting, don't attach it specifically to plaintiffs, because it can also apply to defendants too. It really just depends. What are we trying to protect? Like, what if it's trying to protect a defendant and it's trying to limit a recovery of somebody? That would be protecting the defendant. So if you're looking at the actual law, see and really think about, is this protection? And if so, what are we protecting? Are we protecting somebody's wallet? Are we protecting somebody from getting financially destroyed because of an accident? Are we trying to protect somebody that did get hurt? Are we trying to protect, people coming from out of state harming our residents? Are we trying to protect our residents generally from harm? Like, what are we trying to do? It shifts the loss, okay? Now, loss shifting is typically the preferred way to sue, or what they're trying to do. A lot of times they're trying to get that statute because it really favors them. So sometimes a loss shifting statute can favor a defendant or a plaintiff. It just depends, just like conduct regulating can. But do know that it's really going to be based on domicile. So if you're trying to get a loss shifting statute in the state of domicile of, say, the defendant, because they have a very favorable statute for you, but you're actually harmed in a different state, this law is not going to come across state lines to benefit you, Mr. Plaintiff, just because you want that to apply. So just know, when you're looking at law shifting or conduct regulating, pay attention to who belongs where, because they can't take advantage of a favorable law if they're not domiciled there unless it makes sense to apply that law. Now, when you're looking at conduct regulating, it's obviously about regulating conduct. But when you're looking at conduct regulation, think of like behavior specifically. So this is more like, if like a wrongful death statute actually, that's not a good example because that can come up in either. A good example of this is a traffic law or the rules of the road. We're trying to regulate how you behave on a normal basis, because if we regulate your conduct, we're able to further regulate things that happen in our state. Whereas law shifting is more about, not always, but it's typically has to do more with the punishment, whereas conduct regulating is more about the behavior, the thing that you're doing on a day-to-day basis. So it's more about like, did you break this law for speeding? Did you run this red light? Are you breaching some type of behavior like we told you not to, engage in fraud? Did you engage in fraud? Are we trying to regulate the way that you conduct yourself, the way that you behave? Whereas law shifting is, are we trying to hold somebody else liable? Are we trying to prevent somebody from being held liable? Are we trying to mitigate risk here to protect that person that was harmed or was not harmed? Like, what are we trying to do? Think about like, you're literally like moving the liability from one side to the other, depending on what side of the pendulum you're on and depending on what your state says. So what's confusing about law shifting is a lot of times it's used for a guest statute analysis, which guest statute is to protect a driver from somebody that's in their car from insurance fraud pretty much. But not all guest statutes are going to favor the defendant or going to favor the plaintiff. Yes, it's defendant, I apologize. It's not always going to favor the defendant because it just depends on what the suit is about and it depends on where everybody's domiciled. And so sometimes a guest statute might actually be very beneficial for, a plaintiff or vice versa. It just depends on the circumstance. So don't get caught up and say, oh, guest statute must be law shifting. That's not necessarily true. Because again, you got to take a step back and look at, okay, what's the real reason for this law? It might look on its face to be law shifting, but it might actually be conduct regulating. Sometimes there are cases where they're a little bit of both. And if you have one that's a little bit of both, you have to ask yourself, okay, I got to continue then. And the reason this is important as well is it really helps you figure out the interests, right? If our interest is in protecting somebody, that's probably a stronger interest than conduct, because obviously if we control conduct, we can protect people, but we typically want people to be made whole after something bad happens, or we want to protect people from getting taken advantage of in certain liability situations. So these don't necessarily weigh in favor of either, but you can't apply a law if they're not domiciled there. You can't take advantage of a law that would not be fair to apply to you. Sometimes, even if you're not domiciled there, that a law would apply, but it just depends. Okay, it depends on where everybody's located, depends on what they're trying to do. So if a law is supposed to benefit, say, only a defendant, and a plaintiff sues in their home state, and they want the law of their state to apply, and the law of their state is supposed to protect the plaintiff. Well, they would probably apply that law as opposed to the law shifting law, because the domicile matches the policy, purpose, and reason of the state and of the suit itself. And you're like, why are we doing this? I'm telling you, we're doing this because it's going to lead us to the law conflicts. Let's say after we look at law shifting and conduct regulation, we cannot find a match between domicile, where the suit is, and with the purpose of the interest of the law and the reason it exists in the first place. If they don't all match nice and clean, then we have to go to law conflict, but you should go to it anyway. And the law conflict is going to take the gist of this, and it's going to put it in here under 3 separate categories that it could fall into. So let's say both states clearly appear to have an interest in the case based on what it was, a law shifting or a conduct regulating type statute. Say that they both have a very strong interest. Okay, now what do we do? Well, let's see. Is it really a completely strong reason? Do we really have that much of an interest? If you feel like, after really looking at this, both states have a very, very strong interest based on the policy, based on the reason that we have this in the first place, based on what happened, both states really care about what happens in this litigation. That is what we call a true conflict, because both states have such a strong interest that we cannot seem to separate it or decide which one's greater than the other. If there is a true conflict of two different laws competing against each other and there is no clear winner, that's what we call a true conflict. If there is a true conflict between state law, we will have to apply forum law. Forum law is the law of where the suit was filed. So if I bring a lawsuit in Virginia, the suit is going to be filed in Virginia, right? And say it's about California law versus Virginia law. We're going to apply Virginia law because that's where the suit is. Now, you're like, what if it's in Delaware versus California and we filed in Virginia? I have no idea why you would have filed in Virginia, but if you can prove that there is subject matter jurisdiction or personal jurisdiction somehow, they'll probably apply Virginia law, which is so dumb. But I mean, if there's a true conflict, like what are we supposed to do, right? Now, I think of it like this. You know when you have like little kids and they're fighting over a toy? Well, you know, if you're going to fight, nobody gets it. That's what that means, pretty much. If there's a true conflict, nobody gets what they want, we're going to apply this. Now, if one of the states in conflict is the forum, then they get what they want. But that's an easy way to remember it if you think of it like that. Now, there's another type of conflict, and that's where we have two states that seem like they have a true competing interest. But when you really look at it, technically one state does not have an interest as strong as the other. It doesn't have an interest at all. All states care if people get into car accidents. They do. And all states have regulations regarding the conduct of driving. And all states have rules regarding liability for bad driving. An example of a conduct regulating thing is negligence, right? And, you know, there's wrongful death statutes. There's also, you know, the guest statute or a cap on damages or no cap on damages, whatever. So if you have a situation like that, you're like, okay, there's a car accident in state Arkansas, and the two people are from Illinois. Illinois law has an interest in, you know, protecting widows of people that were killed, of their husbands were killed in an accident. And let's say in Arkansas, there's a law that says that they truly care about the safety of their residents and they do not support giving extra benefits to widows, but they do support damages. Both states have an interest. Arkansas cares that there's an accident there. They want to protect their residents from harm. And obviously, Illinois cares deeply about if their widows are in a car accident or their spouses, and they want to be able to protect people. But wait a second. Both the people that were in the accident are from Illinois. Are they a resident of Arkansas? So does Arkansas really care about fixing or regulating or punishing the conduct or behavior or consequences related to something that people did outside the state, in their state? Not really. I mean, they want to punish people if they criminally did something poorly. And so typically a tort that's committed in that state has a stronger interest, you would think. But in this situation, technically, the one that has a stronger interest here is Illinois. It was their people that were domiciled there. They may have caused a tort in another state, but they have a greater interest in regulating the conduct of their citizens than Arkansas does in punishing people that don't live there. Arkansas has a greater interest in protecting their citizens, and if they're trying to sue under a widow benefit, why does Arkansas care if widows are taken care of? The answer is they don't care. Not because they hate people, but their job is to protect their people. And Illinois residents are not residents of Arkansas, so why would they care? And something like that would be what you would call a false conflict. Although it looks like both laws apply, or both have an interest, take a step back and objectively think, would this law really care if this law wasn't applied? Would this law really care if it was applied? Would this state have an interest? Would they care? Would it upset them? Would it bother them? What would happen if you applied this law or this law? How would that change the outcome for the parties? And taking a step back, and if you're, say, the governor of that state, what would you think about that? Would you think that sounds fair? Would you think that sounds unfair? Would you think that that's strange or weird? And when you think about that, that'll help you figure out if it really is a true conflict. And in those situations, you'll probably find that it's a false conflict. Let's say they sued in Arkansas, but it was a false conflict. They're going to probably apply the law of Illinois. Why? Because that's the interested state. When you have a false conflict, you apply the law of the state that has a stronger interest, which is typically going to be, not always, but it's typically going to be a different state than the forum, because that's, they're arguing over something for a reason. They're arguing about which law applies. Now there's another one called undisclosed, and this is where it's clear that nobody cares about what happened. In that first example I said, California resident, Delaware resident, get in a car accident, and for some reason they file in Virginia. Virginia doesn't care, right? And obviously, like, these other states, they care about what happens with, like, in their states. They don't necessarily want people from their states committing crimes in other states, but do they really care how these people are punished for a tort they committed somewhere else? Not really. So there's really no stronger interest here. If there's no competing interest or no clear answer, or it seems like nobody would really care what a law applies, and it doesn't seem like there's a really strong interest either way, you're actually going to apply forum law, which is the law where it was filed, because, at the very, very, very least, the court where the suit was brought has some minor interest, because at the very least, the case was brought to them, it was filed in their court, at the very least, they have that going for them. So kind of, it's not as hard as you think it is, but the biggest bulk of it is really law shifting versus conduct regulating. So that's kind of how that works. Now the last one is called the interest balancing test. So even if you find that, it's a law shifting statute and it makes more sense to apply this law because the purpose of this law is to protect, plaintiffs that have been injured by people from out of state, and there is really no, actual conflict. It's a false conflict. Obviously, the state where the injury occurred, they have the true interest because it actually involves one of their residents, and it involves a policy and rule and law that specifically is about protecting their people. That's what's at stake here. But we're still going to, just in case, look at what is known as the balancing test, which means we're going to count contacts. But not as excessively as we did with the second restatement. We're going to look more specifically just at the contacts and the domicile. But really, it's almost exactly like section 188, subsection 2. And you can apply it to contracts or torts or property, whatever. So when you're looking at the governmental interest test regarding this, just think about how we talked about 188, section 2 for contracts. What are you going to look at for contracts? You're going to look at the state of negotiation. You're going to look at the state of the contracting itself, so where it was signed, all of that. Then you're going to look at where the contract was supposed to be performed or where it was performed, and always trace the money, because you can look at partial performance, but when you're not sure, look at where the money was supposed to change over hands. Then you obviously are going to look at the subject matter of the contract. What is the heart of this contract? Where is most of the stuff where the contract's supposed to be happening? Then you're going to look lastly at the domicile of the parties. That's going to be their place of incorporation. That's going to be their principal place of business. That's going to be where they typically hail from, if you will, where everything is, their license, their residence, their workplace, all of these things. So you're going to count those contacts for either person if you have a contracts issue and you're looking at governmental interest. If you have a tort issue and you're looking at governmental interest, when you're looking at this, what you're going to ask is, where did the injury happen? Where did the contact that led to this injury happen? Who was involved, and what's the center of their relationship? Are they people that know each other just because of this accident? Are these friends that were in a car together? Are these co-workers? Are these people that have been friends for years and they're from different states, but they have a tendency to talk on the phone a lot from different states, or they have a tendency to drive from their respective states to Arkansas for a reunion? Think about where is the majority of their interaction taking place. Then you look at the parties in the suit and you say, okay, where are these parties domiciled? If it's a legal entity, where's their principal place of business, or where their place of incorporation is? And you're really just counting those things. So if you do 188 section 2, you'll reach all the points that you need to. Because even if law shifting is in favor of Arkansas and the false conflict is in favor of Arkansas, after looking at contacts, it kind of doesn't really make sense to apply Arkansas law, it makes more sense to apply Illinois law, then you might still end up applying Illinois law anyway. And that's pretty much the gist of it. It's a lot easier. I think the book really is going to come from law shifting and conduct regulating more, because that can be kind of messy. And sometimes a law is both. And sometimes it really looks like that, you can't really determine a conflict. Most of the time when you have, unfortunately, some type of fact pattern regarding this type of test, it's probably going to be more of a true conflict or an undisclosed conflict, because that allows you to fight over here with section 188.2, and that provides more analysis and you're able to get to a more clear answer. Conclusions are important, especially with this test, because there is less to think about, so you have to make sure you get it correct. So that's pretty much all for the 3 branches, the 3 different types of analysis. Now we're going to finish our eaten away with our why, which is the very last step for every single analysis, and we should be done.